Okay, our next item is going into executive session. The City Council may enter into closed executive session pursuant to the meetings of the Open Meetings Law, Chapter 551.071, Government Code Burnham's annotated in accordance with the authority contained in the following section. This will be Section 551.071, consultation with the City Attorney. And we'll be considering two ordinances proposed by the initiative petitions captioned as follows. Number A, an ordinance amending ordinance Article 13.04.101, Division 3, maximum allowed price differential between the total cost of electricity paid from its wholesale electric provider and the total price charged by and through the City of Coleman while operating as a municipally owned utility. And the second one is an ordinance amending ordinance Article 13.04.101, Division 3, electrical, requiring that the municipally owned utility be divested within a designated time. So at this time I'll entertain a motion that we go into executive session.
Mayor, I'd like to make a motion that we go into executive session.
Okay, I have a second.
Second.
Okay, motion's made by Councilwoman Merriman, seconded by Mayor Pro Tem Payne. All in favor, aye.
Aye.
Opposed, nay. Okay, so we'll go into executive session at 6:21. Okay, at this time I'll entertain a motion that we return to regular open session. I make a motion that we return to regular open session.
Second.
All in favor, aye. Opposed, nay. Okay, so we're back in executive, in open session at 6:55.
Mayor, I'd like to make some comments if I could, sir.
Okay, sir.
This is primarily for the citizens of Coleman, the benefit of the citizens. Two ordinances have been presented to the City Council for their consideration under the city's charter and the initiative provisions. The first ordinance is entitled An Ordinance Amending Ordinance Article 13.04.101, Division 3, maximum allowed price differential between the total cost of electricity paid from its wholesale electrical provider and the total price charged by and through the City of Coleman while operating as a municipally owned utility. I'll refer to this ordinance as the rate cap ordinance. The second petition ordinance is called An Ordinance Amending Ordinance Article 13.04.101, Division 3, electrical, requiring that the municipally owned utility be divested within a designated time. And I'll refer to this ordinance as the divestiture ordinance. Craig Allen asked me to review these ordinances back in January this year prior to circulating the two petitions for initiative. After reviewing the ordinances, I spoke with Mr. Allen later that month and told him that neither ordinance was a legal topic for initiative. My legal opinion has not changed. To be a legal topic for initiative, the subject matter of the proposed ordinance must be legislative in character, and the subject matter must not have been withdrawn or excluded by general law or the charter from the field of initiative. I want to first discuss the rate cap ordinance. Texas case law has unanimously held that the establishment of rates by City Council are not legislative in character, and or even if they were legislative, the establishment of rates by City Council are withdrawn from the field of initiative and referendum. Not one single case in Texas has upheld as valid a petition for initiative or referendum seeking to establish or repeal city utility rates or rates for public utilities in a city. State law also provides that the Coleman City Council is vested with the exclusive jurisdiction to establish rates applicable to its electric MOU. Therefore, state law removes the establishment of rates by MOU from the field of initiative and referendum. Further, the City of Coleman Charter prohibits the citizens from proposing an ordinance through the initiative process that would have the effect of repealing an ordinance appropriating money. Section 4.01 of the Charter provides that the initiative process may not be used to propose an ordinance appropriating money or an ordinance repealing an ordinance appropriating money. The city's ordinance establishing its electrical rates for the city has the effect of appropriating money for the city's provision of electrical services and its budget, and the rate cap ordinance effectively repeals it. Lastly, the rate cap ordinance cannot be enacted because it would violate and or impair various contracts and agreements the City of Coleman has with its creditors and suppliers, which require the city to stay solvent, and part of that is having high enough rates to not only pay the city's bill, but to run the city. These are the primary, but not the exclusive reasons why the rate cap ordinance is not a proper ordinance under the initiative process. Now let's discuss the divestiture ordinance. The subject matter of the divestiture ordinance has also been withdrawn from the field of the initiative process under the following two reasons. Under Section 1.03 of the city's charter and state law, the City Council does not have the authority to enact this ordinance divesting the city of its MOU without seeking the prior approval of the voters. State law provides that there can be no right or power existing in the citizens of a home rule city to adopt an ordinance through the initiative process if the power to adopt it is not lodged in the City Council in the first instance. Also, state law, just like it does for the rates, provides that the Coleman City Council is vested with the exclusive jurisdiction to manage and operate the city's MOU. Therefore, state law removes the divestiture ordinance from the field or initiative and referendum. These are the primary, but not the exclusive reasons why the divestiture ordinance is not a proper ordinance under the initiative process. Citizens of Council?
Council, any comments or questions on this? Do we have anyone that wants to speak on this subject? I don't have anything here. Okay, the item says, okay.
Mayor and members of the City Council, my name is Roy Poage. My address is Post Office Box 591 in Coleman. According to the rules and procedures for the City Council meetings, I have 3 minutes to speak, but it may take me to a couple of minutes longer if that's permissible with the council. I've been coming to these meetings for 10 years. This is the first time I've ever asked to speak to the council, and I thank you for the opportunity. I'll make this fairly brief if I can. Let me begin by saying that it is time to set the record straight on how these two petitions before the council were obtained from the Coleman voters. I submit to the council that these two petitions were obtained by deception. The party or parties seeking signatures on these petitions gave misleading information and sometimes used outright falsehoods in order to get Coleman citizens to sign these petitions. For example, they mailed out a card through the mail. It was delivered to citizens through the United States Postal Service. The card read as follows: selling the system would result in 25% to 50% reduction in your electric bill. There is no evidence of any guarantee or selling the system would reduce people's electric bills. Second thing, so many have come to believe that this is on the card, statement on the card. So many have come to believe that we cannot sell it and get out of the contract. That is not true. Other electrical providers, including the co-op, are willing to purchase the contract and provide us electricity at a substantial discount. This is false and a total misrepresentation of the truth. And this question was asked of the co-op during the town hall meeting 4 years ago. Would the electricity rates be reduced if the co-op purchased the electrical distribution system? The co-op said they'd have to honor the AEP contract until it expires. I met this morning with Mr. Clint Gardner, the city co-op manager, the co-op manager of the city of the Coleman County Co-op, and asked him if he'd told anyone in Coleman that the co-op, without question, would reduce the electricity rates if the co-op bought the Coleman's electrical distribution system. He said emphatically no. Let me have a copy of that. I have given the council a copy of a letter that Mr. Gardner wrote to me after our meeting this morning, dated May 21st, 2015. Mr. Pogue, as per our conversation of this date, please be advised that in the event that Coleman County Electric Co-op should purchase the City of Coleman electrical distribution system, the Coleman Electric Co-op would not be able to guarantee the reduction in electricity rates to the citizens of Coleman until the AEP contract expires in 2018, or until and if a contract is ever negotiated between AEP and the Coleman County Electric Co-op. Finally, my final statement on this is that Mr. Allen has threatened to sue the city if the council does not approve these two petitions. My suggestion to the council is, if Mr. Allen or one of his associates sues the city of Coleman, I suggest for the benefit of Coleman, Coleman citizens, that the city council consider a countersuit charging these petitions were obtained by misrepresentations and falsehoods using the United States Postal Service as a vehicle to promote these deceptive acts. Most of the people in Coleman know that the mayor and the 4 city council members want to do what is best for Coleman as a whole. They realize the mayor and the city council want to see the city achieve its potential and economic and social development. This is the reason that you were elected to office. We need to work together to get this done. This electrical thing has got to be a problem that should be a problem. You should be able to come up here and sit down in a normal tone of voice and reason out this thing so it could be worked out. I'm glad that the council is going to hire somebody to evaluate the finances of the system and of the city so that going forward we can make a rational decision. In 2007, when its electrical contract was signed, the city manager at that time told us he was being hounded by citizens wanting to do something about the electrical rates because they started going up and they could see in another year they were going to be higher. and he felt that he had to do something. So they hired a consultant, an engineer consultant. Electricity rates is based on price of natural gas. Natural gas is a commodity, just like oil, pork bellies, corn, barley. All these things are commodities sold on the Board of Trade in Chicago. Nobody signs 10 years to buy something 10 years in advance. Rather than having a person that specialized in commodity tradings to advise the council what to do, they hired an engineer, which was a big mistake, as we all know now. If you want a contractor for a year or two, that's fine. 10 years, that's unreasonable. It's terrible risk. So we need to quit blaming people and start working together to get this done. And I appreciate and compliment the council on having this study done. I want to thank you for your time, and I thank you for serving. You have a very difficult job to do, and I wish you the best of luck.
Okay, the agenda item says this is for action as a result of the executive session. Following executive session, the city council may consider, discuss, and/or take action regarding one or both of the proposed ordinances. So at this time, I'll entertain a motion.
I'll make the motion. On the advice of our city attorney, I move the city council take no action and/or reject both ordinances presented by the city council, or to the city council, by petitions of the citizens because they are not legal topics for initiative and/or referendum.
Okay, motion's made by Councilman Jeter, seconded by Councilwoman Merriman. All in favor, aye. Aye. Opposed, nay. Motion passes 4-0.